Before the panel members start, I would like to bring a few introduction items to locate the audience. Historically, corruption has always been treated as an illegal act in the penal area in which only individuals would be punished, even though they were connected to a corporation. This approach started to show some limitations, what led the United States of America to start a new way to prevent, detect, and punish corruption, materialized with the Foreign Corrupt Acts Practices Act, Fcpa, 1967. So this made illicit the legal payment of monies from legal persons, then turning into a corrupt act. And this has led to its adoption in international conventions in the fight against corruption, with highlight for the U.S. conventions, but also UN conventions, also called the Merida Convention, signed by Brazil in 2003. In 2006, entered the Brazilian legislation. So following this convention, the legislature proposed a new law which would also bring this into Brazilian law. This was approved in the National Congress in 2013 after people's movements, which has started during the Confederations Cup, FIFA Confederations Cup. So we had the anti-corruption law in Brazil, 12846, objectively punishing legal persons on the illegal acts they performed against the public authority. Also, this law was innovative because it brought from the area of cartel acts the figure of leniency agreements, which usually wanted to put an end to the silence, as following the economic theory prisoner's dilemma. All of this was made available to Brazilian public institutions within an effort of Brazil to have a business environment that was whole and transparent. However, just as with anything in life, we need to take care and with the limitations of the tool. To talk about the theme, we have experts in the area. We will now start with Mr. Christopher Sestaro. As I said, he's the head of the FCPA unit within the Fraud Division, Criminal Section, Department of Justice, DOJ, USA. Christopher Sestaro, you have the floor.
And thank you for the invitation and for that introduction. It's a pleasure to speak with you today. First, I must say that the thoughts and opinions I share today are my own and not those of the Department of Justice. And I am the head of the Foreign Corrupt Practices Act unit at the Department of Justice. The Foreign Corrupt Practices Act is often referred to as the FCPA. And the FCPA is the foreign bribery law in the United States. It has two primary parts. There is an anti-bribery provision, which makes it a crime to pay bribes to foreign officials to obtain business. And then there are also accounting provisions of the FCPA, which require companies that are listed on US stock exchanges to keep accurate books and records and to have adequate systems of internal controls. Those accounting provisions were originally implemented in part to prevent companies from creating slush funds for corrupt purposes like paying bribes. And there is broad jurisdiction under the FCPA. And that jurisdiction is tethered to certain touch points to the United States. The FCPA applies to issuers. Those are companies that are traded on United States exchanges and file reports with the United States Securities and Exchange Commission. And it applies to the officers, directors, employees, agents, and shareholders of those issuer companies. It also applies to domestic concerns. Think US people, US companies. The FCPA applies to US-based companies, companies organized under the laws of the United States, as well as to United States citizens and other US people. And finally, the FCPA applies to anyone who takes an act in furtherance of a bribery scheme while they are located in the United States. Now, the FCPA by its nature is a crime that involves international conduct. Because the crime involves offering and paying bribes to officials of another country, many of our cases involve interactions with authorities from around the world who may be investigating the same case as a domestic corruption case in their own country. These cases are some of the most interesting and complex criminal cases we have in the United States. And as prosecutors, we are very fortunate to get a chance to work in parallel on these cases with prosecutors in many different foreign countries. There are also very important cases. Corruption harms the very fabric of society. It erodes faith in the rule of law, and it hurts innocent citizens. Having the opportunity to assist other countries in their fight against corruption, as well as working to improve the culture of compliance among US individuals, US companies, and international companies, is truly an honor. And I want to take a moment to acknowledge and to express my amazement for the work that the Brazilian authorities have done over the last 5+ years fighting and prosecuting corruption. The prosecutors, the federal police, and the other enforcement authorities in Brazil have brought an astounding number of important corruption cases and have done a truly remarkable job of holding both companies and individuals to account for their corruption. Speaking from my own personal experience, I can unequivocally say that the Brazilian prosecutors and law enforcement authorities that we have worked with in parallel during the last 5 years are among the most dedicated and talented public servants anywhere in the world. I've personally been involved in and witnessed the fantastic relationships that the Fcpa unit has developed with Brazilian authorities during the last 5 years. From before the time we reached our first coordinated resolutions with Brazilian authorities in 2016, and continuing to today, the Fcpa unit has continued to share leads in cases, to share evidence and information in ongoing cases, and to work our investigations in parallel with Brazilian authorities on these incredibly important corruption cases. These efforts have resulted in very significant cases being resolved in both the United States and in Brazil. Cases like the Odebrecht case, the Braskem case, the Keppel offshore marine case, the Technip FMC case, and others. These corporate resolutions, which were coordinated with the United States, the Fcpa unit, and Brazil, have resulted in billions of dollars being recovered from companies that were acting corruptly, while at the same time, numerous individuals have been prosecuted in Brazil and in the United States for their involvement in these corrupt schemes. These are very significant cases that have impacts even beyond Brazil and the United States. The Odebrecht case is an excellent example of that. Whereas a direct result of the investigation, prosecution, and announcement of that case, corruption has been uncovered, investigated, and prosecuted in many different countries. I'm excited about continuing to work in parallel with Brazilian authorities in the fight against corruption, and I'm honored to be speaking to you today. Thank you.
Mr. Christopher.
Mr. Sestaro, congratulations on your talk. Thank you. We will now have the second panel member, Eduardo Pasinato. As I said, he's a lawyer, consultant of UNODC consultant, public policy PhD. Dr. Pasinato, you have the floor. All right, perfect. Good morning to you all. It is a pleasure to be here with you. It's an honor to be with the UNODC, to be participating in this technical, professional, and rich debate, which brings different perspectives regarding the proposition for panel 3, which is to discuss international punishment standards. So following our colleague Rafael and the organization of the event, I should also be restraining myself to discuss an initial initiative. What is the UNODC? What is its mission? And then after this first stage, we can delve into what relates to the so-called leniency agreement in the Brazilian legislation, as included not with this word, but with this meaning, with the structuring of a relationship between the public and the private sectors, intended at improving the quality of the investigation and of proof mechanisms, as Rafael said, not just for individuals, but also what we call legal persons, corporations, companies, enterprises, bringing with the anti-corruption law 12846, it's called the compliance law, anti-corruption law, and several instances that have followed suit, like CGU, AGU, with this kind of institutes the objective responsibility of the legal persons. So the UNODC is located in Vienna, founded in 1997. Today it is present in over 150 countries. In Brazil, we are scattered through all 27 states of Brazil since 2019. The intention is to fulfill the complexities of a federative country with a three-part constitution, the federal government, the states, and municipalities, such as Brazil. UNODC is started with a mandate which has its guarantee on international conventions, especially 3 of them, which the UNODC is a guardian. The Convention on Drugs, Convention Against Transnational Organized Crime, which is also called the Palermo Convention, or UNTOC, or the Convention Against Corruption, as Rafael mentioned, also called in the nomenclature of UNCAC, UNCAC, or the Merida Convention. We dialogue directly with the objective of Sustainable Development number 16, which is to promote peace, justice, and effective institutions, being those that are in line, in compliance with international and national regulations in the topic. As Christopher mentioned, evidently, corruption destroys the understanding and the positive perception of the rule of law, and it becomes an obstacle to human development. To bring a few international evidences, the World Economic Forum estimates that about $2.6 trillion are spent every year with corruption. That's the global cost of production, 5% of the world's GDP. The World Bank also has made work developed with the United States, and Christopher, that spoke before me, talks about the payment of bribery by individuals and legal persons. The World Bank estimates that briberies amount to over $1 trillion every year. Aside from the quantitative impact of the economic, social, and political dynamic of a country, corruption also becomes an obstacle to the more qualitative rendering of services and public policies. So there's no doubt that if we want to effective the actual human development conception, the rule of law, and rescue trust, which many times is lost on these legal persons and the other sectors of the society, it is fundamental that we rescue a trust relationship with civilization, which ethics and the culture of integrity must be present in the relationship between the private and the public sector. This is what the UNTOC, or the Palermo Convention, delves into, approved on November 15th, 2000. 20 years, therefore. Brazil was approved in 2003, and then it was ratified on a decree 5015-2004, which internalizes the Palermo Convention in the Brazilian legislation. There is a set of activities, repercussions in the norms of Brazil, which lead to a process of induction brought by this international convention. Aside from the criminal organizations, several other legislations, all having to do with these guidelines. So to this convention, we have 3 protocols underneath. I should mention 2: trafficking in people and trafficking in weapons. These are high volumes of money which cause human suffering. Amongst the guidelines brought by the Palermo Convention, internalized by Decree 5015-2004, there are measures to intensify the cooperation with competent authorities for law enforcement. This is where we see the provision in the Brazilian law. It's called the compliance law. It was then called the leniency agreement, meaning member states create measures to encourage people who participate or have participated in organized crime groups to offer useful information to investigation and production of evidence. Evidently, the prosecution office has several norms in the process. CGU itself also includes the administrative, civil penalties, which come through their executive orders. And we also have a concern that this delivery of information in those who are involved with crime may contribute to deprive organized crimes to use their own resources which have come from the crime. In English, the expression is follow the money. This has effectiveness in dismantling the money laundering and the set of ancillary crimes that come with corruption. So each member state can create this provision, and as it was done in Brazil, with, for instance, the punishment of a fine as a penalty, leniency agreements are information that can help dismantling organized crime in the transnational character and its correlation with the several types of corruptions and illicit acts. Therefore, to finish my first part of the speech, I bring Article 24 of the Palermo Convention, which brings the need to regulate not only those involved in the actual act, but the whistleblower, the ones that denounce, the one that blow the whistle, leading to the location of the products, leading to stories, therefore dismantling economically the whole process. This is Article 24, in which there's another induction so that measures are taken for the protection of the whistleblowers, the witnesses, avoiding intimidation so that this information can be provided and that this public authority can safeguard this person. This is a component of the Palermo Convention that still needs to be improved within Brazil. In the second part, I'm going to delve into the interface with UN Convention or the so-called Merida Convention, bringing some components on Article 12, Article 26, which both bring to accountability what we call objective punishment and possibility of different natures of sanctions, civil, administrative, and criminal, leading to a more full effectiveness of the reality and with the logic brought by this convention incorporated with the Brazilian legislation called compliance law and other infraconstitutional laws. Therefore, establishing this dialogue, not with this name, as I said, but with this scope, the leniency agreement included in the Merida Convention. So far, I thank you. I am at your disposal for debate. Thank you very much, Eduardo. I thank you very much for maintaining yourself within the time frame. It was very clarifying and objective. I am going to go ahead and hand over the floor to our colleague Nivaldo Dias Filho. He is a civil engineer, auditor with TCU, vice president with AUD TCU, and former federal police forensic expert. You have the floor. You have 7 minutes on the first block and then another 7 minutes in the second block. Please, Nivaldo. Good morning to you all of you who are listening to us. Good morning. It's a pleasure to be with you all here. Such a selective group of debaters, of people that are so specialized, who undoubtedly have a lot of experience to share, not only amongst us, but also to all of those who are watching us here today. Well, I think it's consensus that the fight against corruption is fundamental so that the public authority can execute with fairness and efficiency public policies. So when I say public authority, I mean national entities, but subnational entities like states and municipalities in the case of Brazil. And public policies are within the public services provided to citizens, healthcare, public security, infrastructure. When I mention corruption, what I mean is the legal exercise of a private interest on top of a public interest. Many times it shows as bribery, as it was mentioned, but also I refer to that behavior that Professor Susan Rose Ackerman, who's coming later to be with us, defines as rent seeking. Rent seeking in English. This is a behavior which makes individuals to increase their pockets illegally in detriment of the public interest. Naturally, not only public agents, but also politicians are practicing corruption. But there's an important link with these agents with the companies. And it is needed, evidently, to punish the individuals, the public agents, the private agents, because this is fundamental in the fight against corruption. But this also goes through the punishment of corrupt legal persons, which is what we're dealing with right here. And I highlight it's not just to punish, but also promote a series of incentives so that the law is actually fulfilled. So going back to the area that we're dealing with this panel, which is the punishment of legal persons, it should be discussed at this point in time because it is a topic of greatest concern worldwide, and also because Brazil has a new law regarding that, the anti-corruption 12846 2013. It's pretty recent as a law. When we talk about punishing the companies, we don't have the option of putting one legal person in jail, right? This needs to be done as fines or fees or economic deterrence, as we call it technically, like prohibit them to acquire credit, alienate them from their equities, or even require them to shut down. The problem really is that powerful companies can co-opt not just the public engines but also the communication means, and with that they can co-opt the public opinion, making people think that punishing companies is something that should never occur because it would lead to unemployment and other economic consequences to the country. But this is not really a new argument, nor is it correct. It's a fallacy, or sometimes it's too exaggerated because it's a model, a business model, which Mari Henrique Simonsen on October 14th spoke of in 1987. If you want to go to Veja magazine, you'll find it. But if we take into the extreme this concept of protecting businesses and jobs and ensuring economic advantage as a justification for not punishing these enterprises, this would make them immune. This would be pretty unfair to the honest legal persons. Likewise, if a country decides not to punish properly its own national enterprises involved with corruption, this would lead to a competitive imbalance when compared to those that are more strict in the fight against corruption. This is why this theme becomes not only a national concern but also an international one. The international community has been concerned with that. It is not by chance, as mentioned by Eduardo Pasinato, our UN representative, that the countries have started signing conventions and agreements, not just with the UN, but the Merida Convention or the Palermo Convention. They all have this intention of gathering the countries in the fight against this evil, which is so harmful to everyone. But the problem is, how do you know if a legal person is being strict enough or sufficiently punished? Well, this has to do with the relationship between what the company stole, if what they illicitly took over, and how much they have to return associated with the economic consequences of other sanctions and incentives that it suffers. Well, the legal person will be sufficiently punished if they notice that the result of committing corruption was worse than if it had been honest. This serves as an example to all of those who would consider this possibility. They would be inhibited if they would see that the pathway to corruption is not as advantageous. This is why the international conventions, they say about seizure of the products. This naturally might not occur, this deterrence effect, if they deliver a minimum fraction of what they illicitly took over. It's not something similar or mathematical, but there's an economic logic that cannot be left aside. And for that, this approach, as I see, is fully dealt with in the economic law with authors like Becker, Poslam, or Cullinan within this logic of the theory of rational choice. I should stop here, respecting time, and we'll keep going in the second block. Thank you very much, Dr. Nivaldo. You stuck to the time. It was an initial nice talk, very clear, concise ideas. Marcelo Ribeiro de Oliveira now, he's the prosecutor of the Republic, Joint Secretary of the General Prosecution Office. He's taking a PhD in law. He has a master's degree in law with the University of Brasilia. He's also part of Lava Jato Task Force. I would like to hand over to your initial considerations, and then we'll have another 7 minutes for you to add. Thank you, Dr. Marcelo, please. Thank you, Rafael. Good morning to everyone who's here with us, to our colleagues with our virtual table. It is a joy to see a few friendly faces. Dr. Rafael, Chris, Nivaldo, I think we did have one talk once, but we've done a few things together. So it is an honor for me to be here. Thank you very much for the invitation. And specifically on December 9th, on the Week Against Corruption, we are here talking about it. So within the theme, I understand that this first block, just a disclaimer I would like to make that my opinions here are personal, but they are sometimes academic opinions, but they do not represent the position of the institution I represent. These are my personal opinions. So, although it is an introduction, I would like to talk a bit about best practices, about corporate punishment. When we talk about what Chris mentioned, the investigations and stuff, we have multi-jurisdictional experience, especially having to do with the corruption practice, very differently from what we see in other areas like trafficking. We don't do joint investigations sometimes. In corruption cases, action is very segmented. They either occur in parallel, investigations that we call mirror investigations, or successive investigations, collecting elements that have produced in one country, later on going to a different country. When we're thinking about investigation, going all the way to the court. But there's also another piece of information which is minimally despicable, but it should be stimulated, which is the non-trial resolution, which is a possibility of signing agreements before it goes to trial. We have a few actions done in parallel by each state, which is sovereign, to produce its own internal result, other than, I should mention and I should emphasize, the existence of a coordination work, integration work, so that everyone will fully exercise its attribution, its internal space, but without causing embarrassment to the other party or to the entity, the legal person or natural person, to be held accountable. I am saying this because that's one of an important debate which has to do with what we say the bis in idem international, or even the internal arenas, like in Brazil. We can punish more than one entity, the piling on or the overlapping of sanctions. As my position, I don't believe that the bis in idem international should be evoked. I wouldn't agree with it. It does not exist. First of all, because if these are two entities that are punishing, then the norm is different. So it's not exactly with the same fact. This should be polemical, a controversial topic, but I don't believe that Article 4 of OECD Convention should prohibit the bis in idem, since it talks about the need of the states to coordinate their jurisdictions and not just the one that is in line with one or another. So this is necessarily important. And this is in the fact that I would also like to highlight that many times the press distorts what the entities are doing, nationally and internationally. When you keep in contact, when you talk towards obtaining information on the international organization, on the behavior, on the chronology, all of this is an exchange which is not just healthy but also stimulated by conventions in terms of gathering efforts. This is one thing. There's another scenario, which is the one that produces evidences, which disseminates evidences, which is going to be taken forward as a possible class action. And this is something else we need to go through the regular proceedings. And this is what I always say, a difference is that one thing is evidence, one thing is information. One thing is evidence, one thing is knowledge. I don't need, for instance, to have a cooperation agreement to have a copy of the US Code. I can go online, I could do anything, but I can consult our counterparts and I can see how they interpret the legislation. And this exchange of information is the pathway to close this introductory talk. It allows for us to evolve in our internal milestone. As it was said, as a way for the translation is called the Clean Company Act. To us, it is very relevant. It started in 2014. It is just 6 years old. Fcpa is over 40 years, and it took a long time to consolidate. So the fact that we are walking baby steps and we've done a lot, it's remarkable. And we know how much we have to improve. Also, the detection of the best standards for corporate accountability, I should say. There's an agreement with the United States for the U.S. sentences guidelines. We're still baby stepping on how to have parameters to have good sanction. I see on the part of the prosecution office a few regulations. They're still procedural, but I hope soon enough that in the future we understand, given our peculiarities, but we hope that the guides will serve as a north, as a pathway of support so that we can do what matters. There is no deterrence, an effective deterrence in terms of corporate conduct, and that this should not be done in excession. So this needs to be done proportionately. I think that I want to talk about evidence. I wanted to talk a lot, but maybe along the debates we can deepen about that. So, Rafael, thank you. I'm available. Thank you very much. You also stuck to the time. Yes, this will be our second round of discussions. I will follow the same sequence. I should now invite Mr. Sestaro. Allow me, Mr. Sestaro, to take a chance and for our second round of talks to go ahead and ask you if you think you can clarify who are the parties in charge of enforcing Fcpa in the United States. Who enforces the Fcpa in the USA, please?
So the short answer is that the Fcpa is enforced criminally by the Fcpa unit of the Department of Justice, and that the Securities and Exchange Commission of the United States has civil enforcement authority over issuers, over those companies, as I mentioned previously, that are traded on U.S. exchanges and file reports with the Securities and Exchange Commission. And if you allow me, I'll explain a little bit more about how that works and what all that means. So the Fcpa in the United States is a federal law. It can only be criminally prosecuted by federal prosecutors in the United States. And federal criminal laws in the US are enforced by prosecutors located in all different districts all around the country. And each of those offices has prosecutors that focus on all types of federal crimes. And they're responsible for prosecuting the overwhelming majority, nearly all of the federal crimes in the country. But in addition to those prosecutors, the Department of Justice out of DC has certain prosecutors that focus on certain types of crimes. And the Fcpa unit is one of those units that contains prosecutors that focus on specifically the Fcpa. And there are more than 30 dedicated prosecutors in the Fcpa unit. We focus exclusively on investigations and prosecutions that relate to the Fcpa. And under Department of Justice policy, we are the only prosecutors in the entire country that can bring charges for Fcpa violations. So that means if anyone in the entire country, any of those federal prosecutors throughout the districts in the country want to investigate or charge an Fcpa violation, they have to come to us, our unit, and partner with us in that prosecution and investigation. And that has the benefit of having all of the cases centralized in one unit of prosecutors who become expert in the law and the practice under the statute. It also has the benefit of, since these Fcpa crimes are by their nature international, of having one central point of contact for foreign authorities in these cases to go to. And then on the civil side, as I mentioned, the Securities and Exchange Commission has civil enforcement authority over issuers, over companies that are traded on the exchange, that file reports with the SEC, and the SEC civilly enforces the Fcpa against those companies as well as individuals who are affiliated with those companies. And the SEC, like the DOJ, also has a dedicated unit focused specifically on Fcpa. So those are the two primary enforcers of the Fcpa.
Mr. Sestaro, thank you very much. We will go on with the same order. Dr. Eduardo Pasinato, he has other 7 minutes. Please, you have the floor. He's sharing his screen. Okay, thank you. Perfect, Rafael. Thank you. Proceeding and greeting my colleagues for their brilliant talks. It is really an opportunity for us to learn and for the audience to also learn and establish in this meeting this exchange of viewpoints and perspectives coming from the different professional arenas of all of us. So, continuing, I say that let me delve into the UN Convention Against Corruption. UN CAC, or the Merida Convention. It was approved in 2003 at the UN General Assembly. In 2005, as Rafael said, in the Brazilian National Congress, Decree 5687, we approved a decree in Brazil. Now, February 2020, we have data saying that 187 countries are signatories to the Merida Convention, Convention Against Corruption. UNCAC, UNCAC, has the intention or the objective to establishes a few guidelines because it is a global instrument for facing corruption. It is legally binding to each signatory country. The guidelines are minimizing opportunities for practices of corruption, stimulating a culture of integrity, potentialize transparency and social control, and reinforce mechanisms of control and accountability, and also reinforce class actions within the public sector, the private sector, in the civil society. Therefore, a tripod, but also to include the academic world, therefore four-legged, meaning that the academy, universities, institutes of research have to be included. So the convention is organized in 5 chapters. First of all, general provisions, and I will focus on the other 4 chapters. First of all, Chapter 2, preventive measures. Chapter 3, criminalization and law enforcement. Chapter 4, retrieval of assets. Some of these topics have been touched upon by Dr. Nivaldo and Marcelo, and international cooperation, as our colleague Christopher Sestaro mentioned about the nature of this kind of illicit act, or the several forms of corruption that are actually regulated by this convention. As Marcelo said, and Nivaldo as well mentioned, there's a set of propositions or guidelines recommended by the convention in a sense of establishing mechanisms to incentivize or to punish wrongful behavior. Fines, sanctions, suspension of contracts, loss of opportunity of business opportunities, but also working for the prevention of reputation or image damage. Therefore, integrity is good for the countries and good for business. Insofar, not only an ethical obligation to be in line with best practices, trying to do the right in the right way, but also pragmatically speaking, it is an important incentive to be in line and in compliance with best international practices and best national practices. Article 12 of UNCAC includes the guidelines for the private sector, improvement of standards for rendering of accounts and auditing, also development of civil, administrative, or penal sanctions. Within this dichotomy brought by Marcelo, sanctions which are deterrent, yes, but they should be proportionate and they should be efficacious, stimulating competition, which is lost when there's corruption, as well as the appropriation of the public by the private. As Nivaldo said, the central feature, the axiological center of corruption as an indication has to be done, as I said, deterring, but in a proportionate manner, thus guaranteeing the proper functioning of businesses with these best practices. Article 26 introduces the importance of punishment, of holding legal persons accountable. This was included with the anti-corruption law or compliance law in Brazil because they established what we call objective responsibility. Other than the physical responsibility, individual responsibility of people who practice or commit wrongful acts like that and the actual repair for the damage, there is also objective responsibility of legal persons, regardless of their intention or guilt. The identification of an agent on behalf of the legal person which has practiced illicit acts of corruption, trafficking of influence, bribery, whichever other modalities, also to be punished objectively, regardless of the guilt, without prejudice to maintain the responsibility of physical persons or individuals in which you have to prove intent or guilt, and to the set of other articles ruled by the Merida Convention, the UN CAC, which actually focus this relationship between the public and the private sectors. Let me mention a few in a sense of indicating a few gaps, existing bottlenecks: criminalization of corruption, which lead to illicit enrichment, protection to witnesses, we still don't have this in our provisions, cooperation between private entities, national private entities. We still need to regulate lobbying because it's not legal in Brazil. In what refers to the leniency agreement, not with this name, but with this meaning, yes. Article 37 of the Merida Convention, Decree 5687, 2006, Brazil, leads or deals with each state to be adopting measures to reestablish and indicate mechanisms of participation, of protection for those who participate, and give useful information to the investigation, to the criteria, opening mechanisms of rendering of accounts which are given through the cooperation between the private sector, the business sector, with competent authorities in what we call in Brazil leniency agreement, also influenced by the US legislation, the UK legislation, and other international pieces of law. So each state should consider the possibility to predict or to foresee the mitigation of the penalty for everyone accused, which may contribute substantially to the investigation or indictment. So there are other mechanisms, including the Merida Convention, which walk towards and building new standards of accountability, objective, not just subjective, responsibility to legal persons in the intention of ensuring the dismantling of organized crime, including transnational organized crime. This is the feature of many of these illicit acts, as corruption, from these international guidelines accepted in the Brazilian legal framework. And at the end, I shall delve into it some more. Thank you very much. Thank you, Dr. Eduardo. Continuing, let me invite Dr. Nivaldo. He has 7 minutes. And then we'll have Dr. Marcelo Ribeiro. At the end of the third block, we're going to have questions. We have many questions here in our chat, including demonstrations of support to your talks. So Nivaldo, please, you have the floor. Taking a chance on what my colleagues have spoken, I would like to approach an interesting aspect that was mentioned here. Mr. Sestaro, DOJ representative, explained that the amount of people that are effectively involved in the application or enforcement of the Fcpa brings to mind a huge difference between the US and Brazil, to the extent that the application of the sanctions to legal persons in the United States based on the Fcpa is restricted to a reduced amount of entities or agencies, therefore public agents, which have the legitimacy to enforce the law. This differs very much from the Brazilian reality. The anti-corruption law in Brazil, 12846, says that over 11,000 agencies in Brazil may apply the law, may enforce the law. And when I say that, I include internal controls of all national and subnational entities. What means that each municipality has 2 internal controls ready to enforce sanctions which might reach all the way to 20% of the legal person's turnover. the city hall and the city or township assembly, which would be the subnational house. Also having the federal tier. If you amount to all municipalities, states, and the federal, it's over 11,000 agencies, therefore. If I were to unfold this in the number of public agents which are to enforce the law, I wouldn't even know how to do the math. But the fact is that this leads to illegal uncertainty. Potentially does. I'm not paid to be a lawyer of a company. That's not my function. This is the reason why I am, by force of my profession, to be stuck to other approaches. But it doesn't seem to be fair or just to imagine that the companies in Brazil, the legal persons in Brazil, or those who do business in Brazil, are subject to so much dispersion, spread of agents to enforce this law. This happens because the lawmaker, within the lawmaking process, given the lobbying and even the legitimate processes in writing a law, wanted to include internal control in this prerogative. If within the federal government, most of what happens in the federal executive branch is applied by CGU, the Controller Generals, we still have internal controls in the judiciary branches and the legislative branch, which are also ready to enforce the law. I think this inserts not only an inefficiency, which might kill the principles that Brazil has signed in international conventions, but it should also serve as a source for corruption. I am not advocating anything, but you can only imagine that in a very short period of time we're going to start having scandals of leniency agreements which were signed in ways less than correct. We will have corruption acts in agreements of leniency. We will have corruption acts in situations which involve the fact of not being able to enforce the law. Since the legal security allegedly said has been built in a way of consider bis in idem, to repeat what Marcelo said previously, meaning a double jeopardy, as we say, for the same law included within the same legal framework. But even though, if this does not meet the logic, what's happening is that we're going to set up a bis in idem jurisprudence if someone is actually punished by the same acts that they have already signed in the leniency agreement. This has affected directly the external control arena, which is the area I act, but it has also affected the criminal area and even the civil area. It would be possible, theoretically, to be the jurisprudence which is being built to supposedly give legal security to the agreements that an entity as small as a city hall, as a township of 1,000 people in the countryside of Brazil, sign an agreement with a legal person for acts which may have repercussed in the municipality, and by extrapolating the non-bis in idem understanding, the other entities, the other most structured entities in the fight against corruption, would be prevented from applying other sanctions since the agreement has already been signed with the little town. I am mentioning an extreme example. People would say this is absurd, but we're walking towards this sense. And therefore, we still have time to take necessary measures so we don't reach this extreme. This becomes especially important not only because of the potential loss of objectivity in what the law lays out, but because this would put us in the direction of a situation of not being able to fulfill all and every international conventions that Eduardo introduced. Therefore, we need to discuss best ways of punishing the legal persons, as well as forms of not punishing them or presenting alternative sanctions, which would include whistleblowing models, that to me seem to be involving a further discussion, not only between those who apply the law, but the university, maybe to revise the actual law, then ending up with the capacity of enforcement of the anti-corruption law in Brazil, and putting it in the hands of the prosecution office, which has the tools traditionally taken in the fight against corruption, not only in the penal code, but also administrative law. I think this would be an urgent and courageous measure so we can actually give effectiveness to what has been agreed upon with the nations. Nivaldo, once again, thank you for the explanation. We are now going to close the second block. Let me hand over to Marcelo Ribeiro so he can add on the talks. And at the end of Marcelo, we go into our third block, which would be the Q&A. Please, Dr. Marcelo, you have 7 minutes for us to wrap up our second block. Thank you, Rafael. Taking on what Nivaldo said, we need to explain, Christopher, that is correct. You did not hear wrongly the translation. It's 11,000 agents that can actually enforce the law. If we were to account for each individual, I think it's hundreds of millions, if not thousands, if not millions, which could enforce the Brazilian Fcpa, which would be an absurd. And if we think that our federative model is not as fragmented as it is in the United States, we are very dependent on the federal area, although states do have very efficient mechanisms to take care of their realities. And that's an important thing to mention. One can notice a lack of coordination and a risk, as mentioned, for you to have overlapping double punishments, many entities working on the same fact and on the same evidence. Even if we don't go into the actual punishment, especially because of large punishment rulings, the private entity usually is very well assisted, but there's always the rework, the double work, and the efforts lost with overlapping actions. In terms of just wrapping up of what I said in the beginning, very much focused on the object of our panel about the international standards of punishing the legal persons in terms of activities, of non-conflictive activities and investigative activities. Well, the second block, I think that the gold standard, what would be desirable and which is very well adopted, and the formal channels for sending evidences, but in parallel with some of the cooperation agencies or networks. And I would say the prosecution office, just to make it clear, if we think about some of the channels connected to money laundering, we have a group which is highly qualified forum which allows this interaction between the countries. So I think that the transnational illicit acts needs to be reinforced, like mechanisms of exchanging institutionally instead of just being informal exchange of information, in what the non-conflictive resolution, I would like to highlight the importance of the work of coordination, this discussion, this debate, so that each country will have their own assumptions, their own premises, and that we can take into account the excessive punishment regarding the counterpart. Concluding what Eduardo said, what gives the proportionality of deterrence, not just enough, an expressive punishment or penalty, but also in terms of control of the legal persons. And I say the introduction of compliance mechanisms, especially those that have it in an efficient way, and also a culture in Brazil that's very beginning, which is the self-reporting culture. It is a company that is knowingly that they are doing something which is illicit, they come to light and voluntarily make public. That it would be a reason of, not that there wouldn't be any punishment, but it would be mitigated. I think that's a very important aspect to be emphasized, the stimulus that has to be given to this conduct, this demeanor. Although with this mosaic of agencies in Brazil, this could be a bit more complex. And also, when we talk about change of culture, something that I see in Brazil that is very beginning, very incipient, very connected to self-disclosure would be internal investigations. Brazil has not a culture of making use of internal investigations. It's just happening now. It's showing to be very effective. This happens spontaneously, and also investigating with depth to come to the end or to the bottom of the illicit act. So it would be a proof produced by the legal person in a sense of improving the state's or the public authorities' activity. There was a polemic about the public authority outsourcing investigation. It was a case of a Deutsche Bank, which was not the case in there, but anyways, I should mention, this is not what we stimulate here. We want investigations to actually help the public authority to prosecute individuals and legal persons accordingly. So I think those are my comments. We can go to questions. I'm available at your disposal. Thank you. Let's start our third block. This will be a Q&A session. We have initially 20 minutes, which are going to be for answering the questions that we got in our chat, and then in the end we'll have other 10 minutes. We have a set of questions that I will start asking Dr. Sestaro. So the first question, Dr. Sestaro, Igor Oliveira, auditor, he asked, what has been done in the United States regarding preventive measures of corruption as laid out in many of the texts of the Merida Convention? The next question from Luciene, what is the impact of leniency agreements and the model in which the central entity, which is the federal government, plus 26 Brazilian states, plus over 5,500 municipalities may sign these leniency agreements? What's the impact in your vision? And a comment by Gabriel Leisure. The federal model of the United States should also be applied to Brazil. So it's just a comment. Let me start with Dr. Sestaro about these questions. You can answer quickly, and then we'll have questions to other panel members.
I'm sorry, and the question for me specifically was what? I'm sorry.
The question is, what has the United States done for preventing corruption according to the Merida Convention?
We seek to, at the Department of Justice, prevent corruption by both specific and general deterrence. And we do that through our cases. We prosecute both individuals and companies for FCPA violations. We think it is important and critical in order to be successful in this area that you hold both the individuals involved in the corruption accountable for their conduct, but also that you hold the companies accountable as well. That's key because it provides the specific deterrence of penalizing those individuals and forcing those individuals into situations where they will not engage in that corruption again specifically, but also because then it provides the multiplier effect of deterrence when companies see the massive penalties that are associated with some of these cases in the billions of dollars. Then it deters them, if they are considering engaging in corrupt conduct from doing so. When individuals see that people are going to jail for engaging in corruption, then when it comes their turn, or if they are presented with a situation of whether they will act corruptly, it deters them from engaging in that corruption. And so we think through robust enforcement and prosecution, you can achieve deterrence, around the world. And one of those things, another aspect of that is in each of our resolutions, we also require companies to improve, right? So anytime we have a resolution with a company, one component of that resolution is that they are required to enhance their compliance. They are required to remediate the misconduct. They are required to determine what happened at their company that allowed this corruption to exist, or even fostered an environment where corruption was acceptable. And in order for them to meet the terms of our agreement and be released from that agreement, ultimately, they need to meet very clear requirements that are outlined in an attachment about what our expectations are for their compliance and for their controls. And the idea is that when a company goes through a resolution with us, that they will come out a better company, that they will come out a true, an ethical, and an appropriately controlled company. And we think that is a critical component as well as just the prosecutions themselves in creating a environment of trying to deter corruption.
Thank you, Mr. Christopher.
We have further questions. Let us continue with Dr. Eduardo Pasinato. We have a question from Igor Oliveira. Has UN made studies comparing total amounts calculated by the control network of each country? And how about the effective values which have been retrieved to the Treasury? Has the UN done something which could create like a ranking of the countries which are properly and effectively punishing legal persons with an educational result? And in terms of punishments, Igor is asking that. Look, Raphael, the UN is an organization that is very large, with several agencies which have different mandates. The mandate against corruption is one which includes the UN as a whole, as an organization. The UNODC is the guardian of these conventions, especially the Palermo and Merida conventions, which deal with this greater objective. The ranking of countries is not a practice used by the United Nations, because we're trying not to influence the autonomy and sovereignty of the countries, and to establish a ranking of this nature would end up establishing tension with the signatory countries of these conventions. What we do is, within cooperation agreements, technical assistance, we stimulate, therefore, The translation of these guidelines, meaning the international norms, to internal application and incorporation of the countries in regimes of cooperation, in synergy with different actors. There are other entities, including from the civil society, as Transparency International, which through a methodology which was built since 1995 and revised in 2012, establishes the level of perception of corruption. So they have rankings. In our case, what we have been trying to incentivize, and I should quickly show you a summary of this idea, is the development of new metrics to measure corruption, which may look further to the perception or social perception of what is understood, in which they would do some methodology that would insert like a survey of victimization of corruption. How much corruption victimizes people and legal persons. We have developed a manual on corruption surveys. It is a methodological guideline. There are two sections, one based on the business sector, which based on a sampling technique could establish international references and parameters through victimization of corruption, the actual exposure to corruption and not the social perception of corruption, because there would be an apparent paradox. The more the mechanisms of control, perception, and accountability and preventive measures are developed, the more the population believe that corruption is disseminated and there's nothing to do about it. So we're working through this bias to go beyond ranking. In spite of the ranking, we stimulate surveys of victimization, as we call it. This study started in Mexico initially. Now it's being replicated in Nigeria. And we have been dialoguing with Rede Brasil, the UN Global Compact. It's a global working group, and also CGU, the Controller General's office in Brazil. We have been dialoguing to replicate this new methodology to the Brazilian reality, which would be an innovation, a way for us to talk about what Igor asks, very legitimate question, very needed question, in trying to continue building incentives for this change of culture, which is needed pro-integrity and ethics. Thank you very much, Dr. Eduardo. We have many questions. Everyone's been very complimented here. Let me proceed with a question to Nivaldo. Dr. Nivaldo, Luciane and Valeria are asking, the infrastructure area in Brazil has a few, we call, effects. As it was put in the talk of Nivaldo, he mentioned about an article of Mário Henrique Simonsen from 1987, the risk of opting for retrocess. Recently, I mentioned the fear that the manager, public manager, has of making decisions. There's another, to use the words of those who asked the question, the sophism, that punishing the company leads to unemployment. And Valeria mentions, in order to generate jobs, can we do it all, even commit crimes, comparing drug dealing, for instance? Nivaldo, can you quickly, just 2-minute comment, so we have question to Dr. Marcelo. Thank you, Nivaldo. Yes, unfortunately, we have masters and PhDs that promote this kind of fallacious belief in Brazil. As Valeria mentioned, if we followed along these lines, someone would say, oh, let's not punish or capture or put in prison a certain drug dealer because the drug dealer is generating lots of jobs, people are selling drugs, and they derive income from it. if that individual is put in jail, many people will no longer have income. Please, it doesn't make any sense to keep having this line of thought. Likewise, we must have this same line of reflection when we talk about legal persons who make corruption out of their business model. I'm not saying here that by all means this parameter should not be considered, but it's very easy to extrapolate this limit. And as I had mentioned, this puts the country in inequality with other countries. This is also leading to a feeling of impunity. The same wrongful discourse which is put in press all the time, connected to the fact that by punishing the companies, the construction companies in Brazil, would lead to unemployment, is a fallacy, because this was created by the people who are working in the infrastructure area in Brazil, because those companies which work with public resources, they do not lead to incomes. They only actually generate jobs when there's a contract. So that's very different from a private company that's going to build a building and then try to sell. They develop, they hire, they build the building with their own resources to perpetuate and maximize their profits. If that building is a public building, they will not hire people or anyone else up until they have signed the public contract, which will ensure the guarantee to receive the money, not just to pay the employees and all other costs they have, and to maximize their profits. So this fallacy of punishing construction companies will lead to unemployment was disseminated, and many people believe wrongfully that this is true, and it's not, and that the effect of that would have an impact which is economic. I think that in the short run there could be some impact, a few jobs lost, but the benefit in the long run is much greater, because you end up having clean companies hiring within a clean business environment. Thank you, Nivaldo. We now have a question to Dr. Marcelo Ribeiro, a question from Luciene. Dr. Marcelo made a disclaimer in the beginning of his talk, and it's important for us to respect, but the question is, how do you see, as a member of the university, on a proposal that has been stimulated at AUD-TCU, the proposal says that the leniency agreement should be signed by the prosecution office and taken to the court. What would be your opinion in this regard? You mentioned about bis in idem and the overlapping of sanctions, taking into account your international experience, as you mentioned very well. Could you delve into it to answer our colleague, Luciene? Thank you. I will not evade the question, but if I may make a comment in regards to what Rivaldo just mentioned. I'm talking about the large construction companies and other sectors. That reminds me of the too big to jail talk. Even there's a book about it. Too big companies shouldn't be punished because the economy would be struck too hard. I'm not going to deepen on that, but I think it's very important to highlight two things. Those who actually perpetrate are to be punished. And the other issue is the norm that enforcement as a response to the voluntary wrongful act has to be at least deterrent. or else people will keep on acting with corrupt practices. And if Brazil or any other country does not punish, this will be measured by international agencies, and this will lead to an aura of suspicion. There's due diligence, which is different in countries that are highly corrupt. So it's not in the hands of the public authority to be responsible of that. Too big to jail is not accepted, and we will enforce it. We cannot let this go. We cannot accept it, nor to be complacent with the big ones, because in the future it'll be worse for us. But going back to the specific question, I will be brief. I thank you for the question, and I can speak on behalf of the institution at a higher level even. I think that it could be a good thing. It could be a good thing. I think that in our legal framework, the current scenario, it is not a good thing, but I will explain why. In the federal level, the signing of a leniency agreement is not done internally without any rendering of accounts. This is sent to our Chamber of Coordination and Revision, which is a top-level agency. So if nowadays, given the structure we have, we then send it to another agency in Brazil, it would have, I think, 50 justices and 25 courts. It takes a long time. I'm not even saying how long it would take for homologation, but you have asymmetry of knowledge of the topic, you have asymmetry of will of dealing with the theme. So long story short, we needed to redesign institutionally the federal justice system of Brazil with special courts to deal with corruption. I think it would be a good way, a good idea. But for you to throw this into a court which has environmental, administrative, search, etc., I think that wouldn't be a good thing. It would turn something too special, too technical, in the middle of an ocean of themes that are completely different, of people that not necessarily can deal with it. So it's a possibility, but not given the format we have today. Thank you very much, Dr. Marcelo. I think your answer was very enriching. I think Luciane is happy. We still have a few minutes. I will add, asking one last question to Dr. Sestaro. Question is, how can you prevent a company which has signed an agreement in the penal area to be excessively punished or excessively benefited in the civil area? He's repeating the question in English.
So our approach at the Department of Justice is we have something we refer to as an anti-piling on policy. And what that is it's a policy that requires that when we're resolving a case, that we consider the fines and penalties being brought by other authorities that are seeking to resolve the case on the same misconduct. And what we do is we seek to coordinate with both domestic and foreign authorities who are investigating the same case, and we seek to coordinate our resolutions in those cases where possible. And in those coordinated resolutions, we can credit amounts that are paid to other authorities to reduce the amount of the penalty that the company will have to pay to the department pursuant to our resolution. And so we do that in order to try and avoid duplicative penalties. And in doing that, we consider the equities of the other authorities involved, as well as the national interests in the case of the authorities involved. We've done this with Brazil in a number of cases. Cases like Odebrecht, Braskem, Keppel, Technique, we credited the majority of the penalties in those cases to the Brazilian resolution so that the companies did not pay duplicative penalties. And we also do this domestically in our cases, most often with the SEC, where we'll have a criminal resolution with a company at the DOJ. The SEC may also have a civil resolution with the same company on the same conduct. In certain instances, the SEC will take disgorgement. So we'll take the illicit profits as their resolution, and we will take a penalty. In other cases where the SEC is also taking a penalty, we will, the DOJ may credit that penalty. So the company is not paying a duplicative penalty to the SEC and to the DOJ, or vice versa. The SEC may credit the penalty the company is paying to the department pursuant to the criminal resolution. I think one thing to highlight in this area is that sometimes companies may not make an effort to coordinate. This is how it works when companies are looking to coordinate and acting in good faith. But the policy is not intended to be exploited by companies. So if a company is trying to strategically resolve with one authority and then later come to the department and use that as a sword and say, look, we've already resolved, and so you should leave us alone because we've accepted responsibility here, without involving us in the process, without trying to coordinate with us, then that is not something that we are necessarily going to credit. And so it's incumbent on the companies as well to seek to be act in good faith and try to coordinate with all the relevant authorities, whether that be civil and criminal authorities or multiple criminal authorities in multiple different geographies. And so that's how we address that.
Thank you very much, Dr. Sestaro. We still have a few minutes. If I may ask one last question to Dr. Eduardo. Returning money back to Treasury with certain illegal contracts in which the public money, which is the actual product of the illegal act, this payback, the return of the money, as in Convention of Merida, Article 26, to avoid, this would serve also Article 24, which talks about the embezzlement of the product. Article 31 talks about embargo. Article 37, which talks about retrieving from criminals. Do you think it's really important to return the money back to the National Treasury? How about when you know what is the minimum value which has been stolen? Even if conservative, the UN Convention, can we interpret that it stimulates using this value for immediate return of this product of the legal act, therefore avoiding criminals from being benefited? Can you comment on that so we can close our block before we go to the end? Rafael. Yes. Yeah, I understand that this is one of the most important objectives for having an international system that is then approved and enforced in signatory countries. Yes, monies have to be returned, and many different provisions can be used for this purpose. Recently, we had advancement in Brazil regarding the seizure of goods from organized crime, including trafficking and drugs. The Ministry of Justice redesigned a few procedures a few years back. UNODC worked towards that, so we would reach this higher level of improvement, and also with possibility of leading to the use of goods or resources coming from these returns, so that they would be used for the precipitous purpose of the public sector, which is providing quality services to citizens. I have no doubt that, yes, this will be up for the many managers who enforce the law. And I should conclude that sometimes we are very constrained by international norms, but there's no doubt that this change of culture, aside from the norm and the different institutional changes that have to happen, have to be coordinated with governance and the coordinating character of these not only sanctions but also policies directed towards not stimulating corrupt practices. So governance, leadership, and changing culture, not just organizational within the organization, to change corrupt acts are fundamental. I think they wouldn't be just an indication in the guidelines of international conventions that will actually have the ones to establish a changing culture, but including countries such as Brazil and Latin American Caribbean countries, which have long history, physiological tradition of asset holding, this permeability of the public sector, which is appropriated by the private, the use of public monies by the private sector ever since the very foundation of Brazil. So evidently we're talking about a phenomenon that is nothing new, but it is complex. Given the socio-political, cultural nature of this phenomenon, which is corruption, evidently we must be using this kind of possibility, which is to return the monies to the treasury, because it does set an example and deters others from doing wrong likewise. But many have mentioned here we have challenges in the Federative Republic as Brazil with the tripod, and challenges in governance and coordinating these policies. They all have to be at the center of the agenda. Thank you. Thank you, Dr. Eduardo. We come to the end of our third block. We have 10 minutes left for the four panel speakers to say their final words. So please, all of you, if you can use about 2 minutes for a wrap-up, a closure, please say your closing remarks for such a relevant topic. So let me start with Dr. Christopher Sestaro. Please, your final words. Thank you.
So, I will just quickly say that, in the United States, we have a long history now with the Foreign Corrupt Practices Act of holding both companies and individuals to account for their corrupt conduct, and seeking to provide robust enforcement of these laws. I think it's critical that countries in both institute laws like the FCPA, as well as robustly enforce them, right? Because laws without enforcement are not very productive on their own. And so I want to commend Brazil for just the incredible work they've done, as I mentioned at the outset, in the last 5 years plus of investigating these cases, of prosecuting these cases, of seeking to bring individuals and companies to account for bribery and for corruption. I'm again honored to have participated in this panel and appreciate the dialogue of each of you in trying to enhance and trying to look for ways to improve and look for ways to try to better the approach to enforcement in the country. I wish you all the luck in the world in continuing to prosecute these cases, investigate these cases, and of course, the United States and my office stands ready to assist wherever we can and to continue our fantastic relationship of cooperation and working in parallel. So thank you again for the invitation. I really appreciate it.
Thank you, Dr. Sestaro. Let us now go into closing words of Eduardo Pasinato. His final words, please. Wonderful. So I would like to highlight the honor I have representing the UNODC for having been invited on the International Day Against Corruption to be here with you all, sharing such a high-level table with highly qualified professionals this complex task of fighting corruption in a country as big as Brazil, I have a message of optimism that I wanted to leave for closing. It seems to me that along the lines of what Sestaro said is that we have a normative system, a legal framework which has had greatest advancements in the last 6 years, if we were to consider ever since 1992. It's a set of norms that were created to protect the enforce pro-integrity, pro-ethics. So the internal legislation of Brazil is robust and gives us enough elements in line with the Palermo and Merida conventions, including other conventions of the OECD, the Inter-American Convention, which also focus on that. I would like to say that we still have a few challenges, not only in terms of punishment of the legal persons, but also the relationship between the private and public sectors. It seems to me that it's important for us to better regulate or to effectively regulate lobbying in Brazil. Lobbying based on legitimate defense of interests as a fundament of the rule of law, and also to better regulate. Let me announce we will have a cooperation with ANL and the UK government for 2021, looking for the normative regulation for the protection of the whistleblower in Brazil, and also to qualify mechanisms to know what to do when faced with crisis, emergency crisis, such as in the case of the pandemic of COVID-19. And I think this is another important guideline in strengthening and guaranteeing the stimulus so that information are brought to the public sector in this complex governance theater. As Marcelo mentioned, we need to advance. And as I said, the importance of working for beyond perception so that we can develop in Brazil another metric, a complementary metric of exposure, effective survey on victimization of corruption. That's an effort that needs to be broader, integrated, institutionalized, as Rafael mentioned, with the greatest mediation we were able to discuss. Thank you very much. I am fully at your disposal. I hope that we can meet again soon and we can share the advancements and the challenges that we are collectively facing with the change in the pattern of civilization between the civil society, legal persons, academic world, and the public sector. Thank you. Congratulations for the event. Thank you all for, I have learned a lot. Thank you. Thank you very much, Dr. Eduardo, for your kind words. Let's now go to Nivaldo for, you have 2 minutes, Nivaldo. Yes, I would like to take a chance of thanking all of you for this wonderful moment. Di Bello, congratulations for wonderful mediation. Marcelo, Chris, for Eduardo, for everything we've shared. I learned a lot. I am sure that it will be very enriching for all of us that are here with us and who actually see this video on YouTube further. Thank you very much for those who have made this event possible, especially Lucienne. It's such a very short period of time. She believed this would be possible, and she worked day and night, even regarding all the limitations of the pandemic. I would like to thank all the entities who have supported us, ANTC, ANPR, on behalf of Gominho and Fabio Jorge. Many people have helped us, Thais. They've worked a lot, and this event was made possible. So I want to thank you all for your effort so that this was possible here. I think that the panel actually met its intention, which is to raise awareness regarding the challenges that we have to face in punishing legal persons when acting with corruption, and also the positive or negative unfoldings in the fight against corruption. Thank you all very much for everything. It was possible today. Thank you very much, Nivaldo, for your final words. Marcelo Ribeiro now for your final remarks. Yes, Rafael and other members of this virtual table, I want to thank you for the discussions on something that it's still incipient in Brazil and which interface has a lot to do with transnational arena. I have more to thank than to speak because I learned much more than I spoke. I learned much more than I spoke, and I just want to leave my invitation so that you please participate on the other panels. We're not ending here now. The first panels were extremely interesting, and the afternoon today will be excellent. Professor Rosa Ackerman speaks, her name speaks for itself. So I hope that all of you who can be here later, please do. There's much to be added to your knowledge, your perception on what corruption is and the many facets of it. I'm always at your disposal. Let's meet again in the future. This is almost an endless topic. I always say we need to delve into evidence on the whistleblower. Brazil doesn't have regulation for whistleblowing mechanisms. We still need to improve that. Retaliation is completely unacceptable. Brazil has a long way to go. But once again, thank you very much. And certainly see you soon. Thank you. Thank you, Marcelo. So closing this third panel, fourth CONACON, the National Congress of External Control of Courts of Accounts in Brazil, and also in the second international seminar of AUD-TCU ANPR. I once again thank you, our panel members, Christopher Sestaro, Head of the Fcpa Fraud Division, Criminal Section, Department of Justice, USA. Eduardo Pasinato, a lawyer consultant of UNODC, a PhD in public policies with the Federal University of Rio Grande do Sul. Nivaldo Dias Filho as well, external control auditor of TCU, former Federal Police forensic expert and future president of AUD-TCU, Dr. Marcelo Ribeiro de Oliveira. Thank you very much for your kind words. Also, a Republic prosecutor, joint secretary of the Republic prosecutor, taking a PhD in law as well. He has a master's degree with the University of Brasilia. I had the honor to be the moderator. I am Rafael Di Bello, a mediator. Here I am an auditor with TCU. I work with Lava Jato operation. I take the words and echo what Nivaldo said. Thank Luciene. I would like to thank Nivaldo himself for having brought here such high-level speakers. I also would like to echo the words of Marcelo, inviting everyone to keep here with us and watching the other panels. So let me thank ANTC, Gominho, ANPR, our deepest acknowledgement. So I now close this panel wishing you all a great afternoon. Thank you very much.